Hello everyone, myself Prashant. Hope you all are doing great. Today we will discuss Article 20 of India's Constitution, and this Article 20 comes in fundamental rights, and fundamental right comes under Part 3 of India's Constitution. Let's begin and see all the important aspects of Article 20. Article 20 says that there is protection in respect of conviction for offences. Article 20 guarantees for protection in respect of conviction for the offences to the citizens of India. There are three important elements in Article 20. We will discuss all those three elements. First, talks about no ex post facto. It says that no person shall be convicted of any offense except for violation of law in force at that time. So a person can only be convicted if there is violation of law in force at that time, right? Now it is important to know what this ex post facto means and what no ex post facto means. We will know both the scenarios. We will understand this ex post facto with an example. जैसे आप मान लो कि एक पर्सन है एक्स वाई जेड, और उस पर्टिकुलर पर्सन के पास 2010 में एक पर्सनल बागीचा था, और उस बागीचे में बहुत सारे ग्रीन ट्रीज थे, हरे पेड़ थे उस टाइम। और उस पर्टिकुलर पर्सन ने क्या किया कि 2010 में उन सारे पेड़ों को कट डाउन कर दिया, ठीक है। बट 2010 में जब उस पर्टिकुलर पर्सन ने ट्रीज को कट डाउन किया तो उस टाइम कोई लॉ नहीं था जो कि ये डिक्लेयर कर रहा हो कि कटिंग डाउन ऑफ ग्रीन ट्रीज इज अ वॉयलेशन ऑफ लॉ, और उस वॉयलेशन ऑफ लॉ के लिए आपको इतने साल की सजा है। ऐसा उस टाइम पे नहीं था, ना कोई लॉ था और ना ही ये चीज़ जो है कटिंग डाउन ऑफ ट्रीज वॉयलेशन ऑफ लॉ कंसिडर किया जा रहा था। बट 2025 में क्या हुआ कि एक लॉ आता है जो कि ये डिक्लेयर करता है कि अगर आप कोई भी पब्लिक या प्राइवेट प्लेस पे कोई भी ग्रीन ट्रीज को कट डाउन करते हो तो उसके लिए आपको 10 इयर्स का इम्प्रिजनमेंट है, और कटिंग डाउन ऑफ ट्रीज इज कंसिडर्ड एज वॉयलेशन ऑफ लॉ। ये चीज़ 2025 में आता है। तो व्हाट विल हैपन इन एक्स पोस्ट सिनेरियो, उस पर्सन एक्स वाई जेड के साथ क्या होगा एक्स पोस्ट फैक्टो सिनेरियो में, और जब नो एक्स पोस्ट फैक्टो है, जब एक्स पोस्ट फैक्टो वाला चीज़ किसी कंट्री में नहीं है, उस केस में क्या होगा। सो वी विल नो। तो मान लो किसी कंट्री में एक्स पोस्ट फैक्टो है, तो उस सिनेरियो में क्या होगा कि जो पर्सन एक्स वाई जेड है उसको सजा होगी, राइट। क्योंकि एक एक्स पोस्ट फैक्टो का मतलब ही यही होता है कि भले ही आपने कोई चीज़ पहले किया हो, पास्ट में किया हो, अगर बाद में कोई लॉ आता है और वो लॉ उस पर्टिकुलर एक्ट को वॉयलेशन ऑफ लॉ डिक्लेयर करता है, तो यू विल बी ट्राइड फॉर इट, यू विल हैव टू गो थ्रू ट्रायल प्रोसीजर एंड फेस द इम्प्रिजनमेंट। बट इफ देर इज नो एक्स पोस्ट फैक्टो, तो उस केस में क्या होगा, पर्सन एक्स वाई जेड के साथ he will not come on trial, he will not be convicted for the offense he committed in 2010 जो कि कटिंग डाउन ऑफ ट्रीज है। और वो ऑफेंस कैसे हुआ, 2025 में जो लॉ आया उसके अकॉर्डिंग। तो नो एक्स पोस्ट फैक्टो में जो पर्सन एक्स वाई जेड है, he will not face any imprisonment. The act which he did in 2010 will not be considered as violation of law. और हमारे कंट्री में क्या है, हमारे कंट्री में नो एक्स पोस्ट फैक्टो है। सो आई होप यू हैव अंडरस्टूड व्हाट नो एक्स पोस्ट फैक्टो मीन्स। हियर even constitution says that no person shall be convicted of any offense except for violation of law in force at that time. So ex post facto का मतलब यही हुआ, और a person in our country will only be convicted if he does any act which violates the law enforced at that time. Very important, law enforced at that time. Then further it says that even enactment of such law is prohibited. Even enactment of ex post facto law is prohibited by constitution. Very, very important. Then it says that the person will nor be subjected to a penalty greater than that prescribed by the law enforced at the commission of the act. So a person will be subjected to a penalty only in accordance to the law. What law prescribes, whatever the penalty law prescribes, then that penalty will only be for that person. There cannot be penalty greater than that prescribed by the law enforced एट द कमीशन ऑफ द एक्ट. जो पर्सन कोई एक्ट कमिट करता है. सो लेट्स मूव टू द नेक्स्ट स्लाइड. सो जैसा कि मैंने स्टार्टिंग में कहा कि 3 एलिमेंट्स हैं आर्टिकल 20 में. we'll know all those 3 elements. So we have already discussed the first element or the first part of article 20. Now the second part of article 20 says that there will be no double jeopardy. Now what does this jeopardy means? Basically it means that a person cannot be punished for the same offense more than once. A person will be punished only once for the particular offense. He cannot be punished for the same offense multiple number of times. Then the third aspect or the third part of this article 20 talks about no self-incrimination. What does this no self-incrimination means? So it means that no person accused be compelled to witness against himself. So a person who has been accused will not be compelled to witness against himself, right? So unfortunately this thing जो no self incrimination है, it is only for the people who have money, the people who have all the resources, but the poor section of the people उनके लिए this thing is not in reality. Poor people, the people who are economically weak, they are compelled to witness against themselves, right? They are forced to witness against himself or herself. It happens in police stations. It's the fact, but it's unfortunate. So anyways, so there is no self incrimination. A person should not be compelled to witness against himself. Now let's move to the next slide. So we have discussed all the 3 part or the 3 elements of article 20. Now we will see the exceptions to all those 3 elements of article 20. So we will see the exceptions which is there in the first part of article 20, which is about no ex post facto. Now what are the exceptions in this? So it says that it is applicable only to criminal laws. Very, very important, right? No ex post facto scenario is only for criminal laws, right? Very, very important. In exams, questions can be twisted and said that no ex post facto includes criminal laws as well as civil laws or tax laws. That statement is wrong. Only criminal laws. Further, it says that it is applicable only to criminal laws and does not include civil law or tax laws. Very important. It also does not include this provision prohibits only conviction, not the trial thereof. So it prohibits only conviction, not the trial. Very, very important. Trial is not protected through this article 20 or through this no ex post facto. Then then it says that protection under the provision, it should be P. So protection under the provision cannot be claimed in preventive detention or demanding security. So this no ex post facto or the protection under Article 20 uh, cannot be claimed in case of preventive detention or for demanding security. You should know all these three exceptions which is there for no ex post facto. Now let's move to the next slide. Now we'll see one second. Now we'll see the exception which is there in case of no double jeopardy. So again, it is part of Article 20 only. We discussed earlier also that there is no double jeopardy in our country. Now what is exception in this? So exception is that it's only for proceedings before court of law or judicial tribunal. In other words, it is not available against departmental or administrative authorities. So it's only for proceedings which are before the court, right, or before the judicial tribunal. This double jeopardy thing is not there in case of departmental thing or in administrative authority. So if in departmental case there can be double jeopardy, in administrative or in administration type of thing there can be a case of double jeopardy, but no double jeopardy is only for those matter which is before the court of law or judicial tribunal. But in case of departmental cases or administrative cases, there can be case of double jeopardy. Now let's move to the third part and the exception. So the third part of Article 20 and its exception says that it's about no self-incrimination. It says that it extends to oral and documentary evidence. Very, very important, right? Oral and documentary evidence. This no self-incrimination extends to oral and documentary evidence. Now further it says that further it extends to criminal proceedings only. Very, very important, not civil proceedings or proceedings which are not of criminal in nature. So we are seeing that in case of no ex post facto also civil law, tax laws were not included, and here also in case of no self incrimination also it is limited to civil proceedings. It does not extend to civil proceedings. It extends to criminal proceedings only. Very, very important, right? It extends to those things only which are of criminal in nature. Now this third exception has certain other things like it does not extend to compulsory production of material objects, right? Compulsory production of material objects are not included under this no self-incrimination definition. Then compulsion to give thumb impression, specimen, signature, blood specimen. So if thumb impression has to be given, right, thumb impression, then if a blood sample has to be given, right, blood sample, then signature. So this is not under the definition of self-incrimination, right? If a person has to give a thumb impression, blood sample, and signature for the in case of conviction, right? if it is required in the investigation, or if it is required in the course of law, right? And we see that compulsory production, compulsory production, compulsory production of material objects. So if material objects are to be required during investigation, then the convict can be compulsorily forced to produce those material objects, right? Then it also includes that compulsory exhibition of body. So compulsory exhibition of body also doesn't come under the definition of no self. Also does not come under the definition of self incrimination, right? A person can be compulsorily forced to exhibit his body during investigation or during the course of law. Compulsory exhibition, compulsory exhibition means showing, compulsory exhibition of body, right? So I should know all these 3 points as well, right? Compulsory production of material objects do not come under the self-incrimination. Then giving thumb impression, blood specimen, right? Blood sample, signature, then compulsory exhibition of body. So all these are not included in the self-incrimination definition, and self-incrimination extends to oral and documentary evidence, right? And it does not extend to all these three elements which I discussed just now. And we already know that it extends to criminal proceedings only, not civil proceedings or proceedings which are not of criminal in nature. So I guess I have covered all the important aspect of Article 20, right? And the protection under Article 20 are for citizens of the country. I have discussed each and every aspect of Article 20, so I hope you really enjoyed and learned something from this video. So thank you so much for your time. Thank you again. And next I'll be coming up with Article 21, which is very, very, very important article of India's Constitution. So thank you again. Thank you.